Good afternoon. My name is Becky, and I'll be your conference operator today. At this time, I would like to welcome everyone to the Trauma-Informed Legal Representation conference call. All lines have been placed on mute to prevent any background noise. After the speaker's remarks, all lines will be opened in order for you to ask questions. To mute yourself and unmute yourself during that time, please press star 6. If you should need any assistance during the call, press star then 0, and an operator will come back online to assist you. Thank you. Ms. Kalita, you may begin your conference.
Hi, good afternoon. Welcome again. I want to go right ahead and have the speakers talk because we have a lot of great information to share with you this afternoon. So just by way of introduction, I want to introduce this wonderful speaker we have. Ms. Serena Holte is a project manager of the Civil Legal Initiative at the National Juvenile Defender Center. As a project manager, she leads a group of fellows throughout the country who assist young people in overcoming the legal barriers to their employment, education, housing created by their juvenile court involvement. The National Juvenile Defender Center is a national organization that provides support to public defenders, appointed counsel, law school clinical programs, and nonprofit centers to ensure quality representation in urban, suburban, rural, and tribal areas. NJDC also offers a wide range of integrated services to juvenile defenders, including training, technical assistance, advocacy, networking, collaboration, capacity building, and coordination. Prior to joining NJDC, Serena worked at the Center for Children and Youth Justice in Seattle, Washington. She managed a civil legal services program for former foster youth to help them overcome legal hurdles to their successful transition into adulthood and assist in juvenile justice and civil welfare policy reform efforts. Before moving to Seattle, she was a public defender and civil legal aid attorney in Baltimore City. Serena earned her JD from Catholic University of America, graduating magna cum laude with honors. I would like to turn it over to our speaker for today, Serena Holte, and I'll have you go ahead and present to us.
Thank you, Kalita. Hi, everybody. I hope you have all been able to open up the PDF of my slides. I am very much a visual person and hope that this will be a great way for you to follow along about the conversation that we're going to have today. First of all, I wanted to just say I ask that we just hold the questions till the end because there's a lot I need to get through, but I really have left enough time at the end, I hope, for questions. And if not, I have my contact information on the last slide, but you can always feel free to reach out to me. So I work at the National Juvenile Defender Center, and all of that can mean that we are really trying to help kids who are brought into the juvenile justice system. We would like to make sure that they get attorneys, number one, and then get good attorneys, number two. So that we can really promote justice for all kids. The question sometimes comes up, why is trauma-informed legal representation important? They talk about trauma-informed, all sorts of stuff, but where is it in legal representation? So from my perspective, we are more effective advocates when we have a better understanding of our clients and their actions and their words. And we hope by the end of this presentation, you will have some tools to create an effective attorney-client relationship that overcomes some of those potential barriers created by trauma and a relationship that benefits not only your understanding of your client, but also your representation of him or her. And by being trauma-informed, we're not only becoming more effective advocates, but also advocates who fulfill their ethical duties to our clients in our profession. We're going to talk throughout the presentation about our ethical rules of conduct and how that relates. So now I'm moving on to slide 4, trauma in the juvenile justice system. Why is this important? Well, because kids in the juvenile justice system have experienced trauma. And I'm not going to get through all this because you can read this. I'm going to flip through a lot of things fairly quickly so that we can get to the meat, which is towards the end of this presentation. But understand that kids in the juvenile justice system, many of them have experienced trauma. And next, that many kids in the child welfare system have also experienced trauma. It is a huge issue that many of our kids who are involved in those systems and why we're involved in their lives as lawyers generally means they most likely have experienced some form of trauma. Slide 6, the rules of professional conduct. Rule 1.4, communication. That promptly inform the client, reasonably consult with the client, keep the client reasonably informed, promptly comply with reasonable requests for information, and explain a matter to the extent reasonably necessary. These all go towards building trust and empowering the client, which is very much going to be a lot of what we're talking about here today. Rule 1.3, diligence. Shall act with reasonable diligence and promptness in representing the client. Being prompt definitely is important with our client population, as we can easily lose their attention or their interest, especially if we're not returning phone calls right away or we're failing to reach out. We have to be proactive. Rule 1.6, privilege and confidentiality. Reminding the client that your conversations are privileged and explain what that actually means may help you in building trust. Knowing you're not going to share this information with other people. The only time you're required to reveal the information provided by your client is to prevent reasonably certain death or substantial bodily harm. So therefore, you can tell your client, trust me, my job is on the line. I want to do this for you. I'm required to do this for you. I can't tell anybody else. So this conversation can't go past us. So talk to me. Tell me what's going on. Rule 1.14, client with diminished capacity. So here we get into a question of diminished capacity. And some people, in my opinion, think, oh, a kid's gone through trauma, so therefore they must be of diminished capacity. Whoa, that is so not true. That is absolutely not true. This rule actually requires a really strict definition of what diminished capacity means. And I can tell you, in all my years of legal representation, I've actually only met one client. I was a public defender in Baltimore City for over 5 years, and then I was a legal aid attorney, and I worked with kids at the Center for Children and Youth Justice in Seattle for a couple years. I've not really actually had very many clients I would determine to be diminished capacity. So don't default to this. Don't say, oh, well, my judgment can come in and be a substitute. No. We're going to get into all of that throughout this presentation, but it's so important for you to know that that is very rarely ever true, okay? The slide number 7. There's a picture of a really tall kid and kind of a shorter kid. Age is really not an indicator of a youth level of development. Would you be surprised to hear that these two kids are the same age? So adolescent development, kids are really developing different aspects of who they are at different times. And this picture depicts kids who are developing physically in different ways and at different times. To paraphrase Justice Sotomayor, this is obvious to anyone who has kids or has ever been a kid. Representing kids is very different than representing adults. Kids are different. That's what I want to just remind us of, but also not take that too far. Despite the real difference between young people and adults, it's often hard for us to understand why kids are doing what they are doing. And it's hard to explain it or mitigate it with others or use it in court. So as a starting point, we're going to talk about some of the basics of adolescent development. I'm going to go through this part pretty fast. I am not a scientist. I'm not an expert in the realm of adolescent development. I'm not a psychologist. So we're going to go through this fairly quickly to really talk about, at the end, what this actually means for us. But I think you need to have a general understanding of those basics before we get to that point. The next slide, number 8, is adolescent development. There are 5 different colored circles here: cognitive, brain, psychological, biological, psychosocial, and emotional. Adolescent development is really a process of 5 separate but interrelated domains of development. Each is related, but each develops at different rates and develops different from person to person. No 2 people have the same development experience, so no 2 children are developmentally the same. This is why kids need to be treated as individuals and not some sort of cookie cutter, every kid is going to act this way or that way. Really, every kid is going to be different. So one of the easiest things to start with is talking about the physical and biological. So kids develop differently and especially in puberty. Physically, one may look like a man, but that does not actually mean that emotionally or cognitively he is a man. He's still a boy. And as we've seen in the school-to-prison pipeline, that is a big problem, that young, especially young boys of color, are oftentimes treated like they are adults. We are assuming that they are adults because they have developed differently, or we have assumed that they're developing differently, and we are then attaching that to being a man. And that's not true. So it's the same with all the other areas of development. So we're going to talk about, in slide 9, cognitive capacity and psychosocial capacity. Cognitive capacity includes thinking about possibilities and abstraction, really thinking about thinking in multiple dimensions, and relativity. So the non-concrete aspects of thinking, that is really developing so much. And, adolescent development continues through at least the mid-20s. So being able to think about the possibilities about the future, not really something they can grasp as much. Thinking about what my act that I'm about to do might do to my family, might have consequences for me, not really as much as something that a young person can think through, as well as a person, an adult with a fully developed cognitive capacity. Psychosocial capacity includes relating to others and interaction with their environment, regulation of emotions, and self-reliance and independence, concepts of time and planning. We're going to come back to several of these, but I really wanted to put these on the slide so you could really think about these when you come back and try to process some of that we've talked about. But let's take for a second the relating to others. It's very different. So kids are affected by their peers in a very different way than adults are. As adults, we oftentimes might have problems with peer pressure, but it's just that much more with young people, and it's really an aspect of adolescent development. It's not just because of it's because of their psychosocial capacity still being under development. And I can talk about some of the studies that have been done that show some of this, but if that is of your questions, let me know, and I can share some of those with you. Very interesting studies. So slide 10. Slide 10 is all about just pointing out the fact that this is actually a more realistic view of the previous diagram, because at any given time, this can be what a young person's development is like. Their emotional and cognitive is developing a lot faster than their brain and their psychosocial and their physical. It could also be that their brain and their psychosocial is developing a lot faster, or just the physical is developing a lot faster. At any point in time, these things can differ, and different areas develop more at different times for different kids. So, very complicated. There's so much science behind this that I'm just not going to get us lost in that. As attorneys, you're definitely not the science folks. And so I just wanted to get into a little bit of what that is first before we talk to a little bit more about the trauma, because on slide 10 we're getting into the effects of trauma. And so now that we've covered the basics of adolescent development, what does trauma do to that? Slide 12, adverse childhood experiences. Some of you may have heard of ACEs. So ACEs can include abuse and neglect and household challenges. This is kind of how they've been divided up between these three big categories. And some are even outside the household, and neighborhood experiences, things that they've seen in school, things in their communities, etc. But these are things that point to a young person having experienced trauma. And slide 13, the effect of trauma. What does trauma do? Trauma's impact on a person depends on the type of trauma, the age at which it was experienced, genetic characteristics, gender, cultural identity, and social support, among other factors. So one of the big things is that it tends to stunt brain development. Those who have been traumatized often have trouble with information processing and receptive language, primarily focused on safety and survival. They may miss much of what is being said to them because they're just really trying to figure out, is this a safe place for me to be? Are you a safe person for me to be around? I'm not actually listening to the words coming out of your mouth. The parts of their brains that remain alert to threat have been really almost constantly turned on. And while they have had less opportunity to develop those self-regulation skills, so our emotional regulation is off even more than normal for a young person if they've experienced trauma. Feel overwhelmed by their emotions and simultaneously lack tools for calming themselves down. Sometimes they might appear out of control or overly impulsive. These are signs of things that a young person you might see to be the effects of a young person having gone through trauma. So it's really taking those aspects of normal adolescent development that we talked about, and it might be exacerbated a bit because they went through trauma. And these are some of the ways. Having been repeatedly exposed to trauma, a young person may perceive even neutral environments as threatening, and their brains are being primed to go into survival mode. You might see a young person having hyperarousal, which means they have heightened energy and alertness. They may appear jumpy or have frequent outbursts or become confrontational or aggressive. Disassociation. They have mentally shut down or they've just become numb. You might be talking about this court case that will majorly affect this young kid's life, and that kid just seems so indifferent to anything that's happening. Well, that might be because they've gone through something. Avoidance. A young person may be altering their behavior and daily patterns to avoid reminders of their past trauma. They may start skipping appointments. They may skip, probation officer appointments or court hearings or appointments with you. So these are some very typical responses and effects on a young person, and they're acting out because of it, because they've been through trauma. Slide 14 is something I really want to emphasize. It's reminding us that kids are resilient. They're so resilient. And that often these antisocial, whatever things that kids are doing that we think are problems and issues, most kids desist from any of that. So resiliency, some call kids' natural resiliency ordinary magic. It really is. Kids have this ability to overcome adversity, and it's oftentimes just very natural, and you don't have to do anything to make it happen. It is kind of our self-repair mechanism that we have. Children, even young children, are able to bounce back after adversities because of their natural resources within themselves, their families, and their community. And most young people, approximately 91.5% of youth, no longer end up with involved in a court system. They've desist from any antisocial behavior. They're no longer getting in trouble without anyone ever having to have done anything before. I mean, take a moment, think about yourself. Think about some of your middle school, high school years. What did you do in those years? Did you get into stuff that, I don't know, maybe you didn't get in trouble for? Maybe some of you did get in trouble for. But think about how many of us went and did stuff that at this point, if people had known about it, we might have gotten in trouble and might have actually had juvenile records ourselves. And now, we totally just desisted from that. We just didn't repeat that stuff. It's just part of the adolescent development, growing up, learning lessons. Most of us don't need intervention. Even for kids whose risk-taking we might determine to be delinquent. Most kids don't need us to give them all this stuff and treat them different because of it. They're naturally resilient, and they'll naturally desist from any of that behavior. The bulk of what I want to talk about for the next 20 minutes or so is how do we develop effective attorney-client relationships with kids who have been through trauma? That's really where I want to focus because I think that's our biggest thing. Some people want to talk about how trauma should inform all of our advocacy. And I'm going to talk about that for a minute because I want to make sure we don't miss that. But the foundation should be at how can I be the best attorney and develop the most effective attorney-client relationship with my client, considering all of my ethical duties as an attorney, and how can I best represent this young person. Trauma can interfere with the formation of strong client-attorney relationships by impairing the client's capacity to trust others, process information, communicate, and respond to stressful situations. Understanding that there is effect that the trauma has had on your client can help you modify your approach with those clients. Help prepare your clients for court proceedings in a way that might reduce their likelihood of a traumatic response, and being able to build a sense of safety and resiliency within your client. With adequate preparation, clients may feel empowered by the opportunity to tell their story, and I say only in the appropriate situation, and receive empathetic and effective support from the professionals involved. One of the best ways for young people to overcome the effects of trauma is to develop positive, safe relationships with adults. You are not going to end all, be all, and solve everybody's problem by developing an effective attorney-client relationship, but it helps. And the other thing I just want to note is that we can either aid in the healing process or exacerbate our clients' vulnerabilities through what we do or don't do. We do not need to ask our clients about their traumatic experiences unless it is absolutely related and important to the case in which we're representing the child. Asking the client about these events may re-traumatize them, and that absolutely goes against what we're trying to accomplish in our representation. So I know I use the word absolutely a lot, but I just want to make sure I emphasize how important this is. If it is absolutely necessary, then we need to make sure we are creating the proper environment, asking the right questions, and only questions that are necessary, and that the client has an appointment with his or her therapist right after your meeting. We aren't therapists. And after having the young person talk about his or her trauma and relive the events, the client really must have the opportunity to work through that with the support of a professional therapist. But let me repeat that we do not need to ask our clients about their traumatic experiences. That is not where we need to start. That's not what we need to emphasis on, unless it's absolutely related or important to the case. And also, I just want to note that I'm not a fan of trauma assessment. It tends to do the exact same thing. If the traumatic event doesn't have anything to do with the case in which we're representing the kid, let's not do a trauma assessment. Let's advocate against a trauma assessment. It could totally re-traumatize the young person by having to relive those things. The kid may have already been fairly resilient and been able to move on, but then we're having to relive, and now you're going to have to go through this again. So make sure we recognize that these things are not essential to our representation and to building an effective attorney-client relationship. Trauma-informed lawyering is not a precise step-by-step formula. It rests upon characteristics intrinsic to all positive human relationships: empathy, responsive listening, restraint from judgment, and demonstration of authentic care and concern. Clients' trauma history might affect their cognitive and psychosocial development, which includes their ability to think, process language, communicate with others, which includes sometimes they have nonlinear thinking and expression. That meaning, I don't know if any of you have experience in representing young people already or have had experience having a lengthy conversation with too many teenagers or middle schoolers especially. But when they are trying to tell a story, it's not always going from 1 to 2 to 3 to 4. It might be jumping around from 1 to 4 to 2 to 8 to 6, and that is just natural. What I suggest during your conversation, if that's how your client is responding in your initial interview, let them tell it in the most nonlinear way. Let them get it out. And then you can go back and fill in the holes and try to figure out how everything worked in there together. but it helps them to be able to say it and to get it out first. A client's trauma history can make it difficult to build trust. And so we're going to talk a lot about building trust and what that means. And now we're on slide 16. Many people have been traumatized by the system, by the removal, by being removed from their home, by the courts, by attorneys, being placed in out-of-home placement. And so kids have very good reasons not to trust you because they see you as part of the system. So understand that you have this big hurdle. So there is going to be issues with building trust. Do not expect this to be an instant thing. Don't put in 5 minutes of work and conversation and think, oh, I've now gotten this figured out. This kid's going to totally trust me now. You, through every aspect of what you do, you need to concentrate on remember that you need to be trustworthy and think about the fact that you're the importance of building trust with your client. So considerations in building trust. There's no room for judgment in the attorney-client relationship. Counseling includes providing information and guidance as the client makes the decision. We are not substituting our own judgment for our client at all. It's the client's decision, the client's life. If we're expressed interest attorneys, I understand that best interest attorneys might have a different view as regards to their roles. I'd like to just challenge for a minute in regards to taking into consideration listening to the client and advocating what the client wants and what that can do in his or her life. But we don't assume that just because a kid is 10 or just because a kid has endured any kind of trauma, that he or she cannot make decisions or reasoned decisions for his or her life. There has to be an extra thing in regards to determining the diminished capacity according to Rule 1.14. We also need to make sure our clients feel safe. So this is where we're not judging them. We're not, oh, you did what? Oh, our facial expressions can really come across as being judgmental. The things that we say, having a visual sign of being somebody who understands and that it has a safe place. Oftentimes for LGBTQ clients, it's having a rainbow, a sticker with a rainbow. There's many organizations that have these that send them out. You can get one or you can make one, but that just shows folks you are safe here. I'm not judging you. I'm not treating you any different. I am doing my best for you. I care about you. We're good, and this is safe. Demonstrating that you truly care about the client and the outcome of the case will help the client open up to you. You can do this by being prompt in reaching out to the clients once you have been assigned the case, returning phone calls and emails as soon as you can, getting to Rule 1.3, diligence. You can show care and concern because you are being responsive to that young person. You are being proactive with that client. You aren't sitting in your office waiting. Well, we don't all sit in our office waiting for someone to call, but you don't put that file on the back burner because that client hasn't called you. You make it your responsibility every week to check in. Maybe that client has not made it their most important thing to get accomplished this week to have that conversation with you, but maybe you're calling them and leaving a voicemail message each week is a constant reminder there is this person out there. I can reach out, and when I'm ready and when I'm able, I can talk to that person and call them up, and they'll be available to help me out. That goes a long way. Transparency. So transparency promotes trust and seeks to minimize the client's feeling of powerlessness. Making sure the client understands. We have to talk in a language that the client understands. So sometimes it really takes a lot of work. You really need to work on what are you saying, how are you saying it, so you can think, is this something that a 14-year-old might understand what I'm saying? And one way to find out if the client understands is to ask open-ended questions about what you just said, about what the next steps are, to see if they understand it. Putting things in writing oftentimes is helpful. Not all folks are auditory learners. having things in writing. I do want to caution to having too much in writing. Our attorney-client privilege, we don't want to be broken because the client has now shared something you put in writing with someone else, but some basics of like, your court hearing is this date. You need to bring me these documents. Those types of things might be important. But transparency really helps. Be upfront. Make sure the client knows what's happening and feels safe because they know what's happening. Regularly preview the case milestones, the decisions that the client will make, and events the client will need to attend, such as court hearings and meetings. Make the case as predictable as possible. That gets to Rule 1.4, communication. Predictability is important to making that and transparency, I think, feel really close to one another, that they work hand in hand. When the client feels like not all of the future is totally crazy and I can't figure out what's happening, helping them think out next steps. Next week, 2 weeks after, helping them figure that out step by step, it can help them feel more safe, less on edge. One of the best things I like to help a client feel safe with us is also explaining privilege and confidentiality. That's Rule 1.6, confidentiality information. Helping a client and talking to a client about what we talk about here today, this is privileged. What does privilege mean? Don't use the word privilege and expect the young person to understand. Say, so this is what it means. And this is how I talk about it with my clients. I say, so you might be working with social workers and other case managers and et cetera that tell you what you talk about with them is confidential. So with me, it even goes a little bit further than that. So with me, I can't tell anybody, absolutely nobody. And if I get up on the stand and the judge asks me a question about what we talked about, I would say, sorry, sir or ma'am, I can't answer that. My conversation with my client is privileged. I can't tell you that. Now, social workers and other case managers and other folks on that way, they might actually have to answer a question from a judge about what you talked about. But with me, it's held as a secret, and no one else, without your permission, is going to find out. That, I feel, being one of the very first things we have a conversation about, really starts us down a good path of building trust. You also need to follow through with what you say you're going to do. Rescheduling meetings at the last minute. I know it's not always avoidable, but we really need to avoid it whenever we can. Making sure that we keep the appointments. Sometimes we might get mad that a young person doesn't keep their appointment with us, but as long as we're available and we're not rescheduling all the time, that shows our consistency. That shows that we're following through with what we're going to do. If we say we're going to call next week, we call next week. Ask the client what would help him or her feel more comfortable and how you can best work with him or her. So ask the client, I really want to be the best lawyer for you that I can be. Talk to me and tell me, are there things that you think would work better? And make, are there dates and times that work better for me to call? Do you feel comfortable being in my office, or do you think we need to meet somewhere else? And obviously you need to be smart about where you meet because you still want to make sure you have a privileged conversation, but maybe being in an office space is not a space that makes them feel comfortable and safe. So think about these things and ask the client. Maybe the client knows, and maybe the client can share that information with you. And remember that once we've gained the client's trust, we must do everything possible to not break that trust. Building trust is over and over again one of the biggest barriers working with young people in general, but even more so working with young people who've been through trauma. Slide 17, the attorney-client relationship. A strong attorney-client relationship will do all of these things. By building stronger relationships with our clients and doing all the things we just talked about, we can improve our client engagement and achieve better client-directed representation. We give the client a voice in decisions that affect her or him in a way that is powerful, purposeful, and exceeds the baseline ethical requirements. We're not here talking about just everyday representation. We at the National Juvenile Defender Center talk about excellence, and I'm talking about what we can do that's above just the baseline. What can we do to be excellent attorneys for kids? It's truly empowering. It validates the client's strengths and helps the client develop decision-making and other life skills when we let the client voice come through in our representation. Sometimes you may be the only person who allows the client to make the decision. The client may feel victimized from the trauma, and your representation might help them feel more empowered and capable of handling decisions and speaking for him or herself. You hear me say over and over again, empowerment, empowerment, empowerment. Really, our representation can give that to a young person, and that's what should be one of our goals. I have had many young clients that we have had this situation with, and where we've had to develop attorney-client relationships. The client I can think of most recently is a young person in South Carolina. My job, I supervise several fellows throughout the country who are providing direct civil legal services to kids who are reentering into their communities after juvenile court involvement. One of my fellows told me the story about a young client of his, and it just is so encouraging to me that my fellow got what I was talking about when we talked about trauma-informed legal representation and effective attorney-client relationships. When the attorney first met with the client, it was a really hard conversation. The client was not wanting to answer questions. The client was really disassociated with the whole thing, just wanted it all to be over, etc. This was for a school discipline hearing. And the attorney just kept at it, kept asking questions, kept being positive and talking to the client. But the client just really was difficult to get to answer any questions, get to be responsive and engaging with the conversation and direction of where things should go, other than the client wanted to stay in school. So when the attorney was having a hearing in front of the school hearing officer, school discipline hearing officer, the attorney was just asking question after question after question and really getting at the issue and really bringing out the fact that this is not this kid's issue. You are treating this kid in a really treating this different, and you shouldn't be expelling this kid. And the kid really started responding. The client really started responding and got really engaged and thought, oh my gosh, this person is not just somebody who is like a lot of other attorneys I've worked with or like a lot of other adults. He's really here advocating for me with everything he's got. And at that point, that client just was so engaged. He was writing down notes. He was, after the hearing, he couldn't stop talking to the lawyer. And sometimes that's what it takes. The kid's got to see you in action. Kids got to know you are there for him or her and that you've got their back and you're going to work with them. So some of the tips and tools of representing young people who have potentially been through trauma. Interviewing tips include, number one, as we just talked about, I moved up this from when it shows up in your slide, but I think roles and expectations are probably the first thing that we need to make sure we remember, that we have to make that clear with our clients first. This is where we begin forming a trusting relationship. One of the very first things we talk about with our clients is the attorney-client privilege, which explains my role, what I'm going to do, and then I explain what your role is and what you can expect from me. The other thing to make sure of is when you're talking about all of this is not to oversell what you can do. When the client realizes that you didn't fulfill whatever it is that you said you would do, then that can majorly damage the trust that you've managed to build. So we have to be upfront, 100% transparent, and don't oversell our roles and expectations. Promote safety. You need to promote safety with the physical aspect of the space where you meet. This is something I've seen a lot, that just the makeup of the room the location of the space affect whether it helps a client feel safe. I oftentimes will have a desk in the room that I am sitting behind, and that where the client is sitting, there is a clear, direct path for that client to get to the door. There is nothing that's going to block that client to get to the door. Sometimes what I've heard is that clients have, in their heads, just been really focused on what can I do, what if something happens, and they're really thinking about safety, how can I get out of here, and you thought you've had an engaging conversation, but that's all that's been going on in their heads. Absolutely limit the amount of interruptions, and spend as much time as you can, especially in that initial conversation, to get all of the information that you can. You know, you might trigger some issues if you are constantly getting interrupted to do something else, or that you didn't, schedule enough time to meet with this client. I only have 30 minutes, that's all we got, blah, blah. That doesn't build a whole lot of trust. So making sure that you build in the time and making sure that you limit the amount of disruptions or interruptions that there could be. Triggers, I could go into a huge conversation about triggers. Understand that any abnormal responses that you might get, and I put abnormal in quotations, that you might get might be due to some sort of trigger. Something may have happened, and that kid is now acting out because of that. And I put abnormal in quotations because this is really normal. Something has happened, and this young person is concerned for their safety. This young person is concerned for, am I going to eat tonight? This person is concerned for all these other things. And we just have to be aware that that might be why this young person is acting or saying certain things. We need to be culturally competent. I'm not going to get into too much of that either because there's a huge aspect of that. I can talk to you all about that later. And for patience and humility, I just want to mention that you and your client are bound to mess up. Do something that's less than perfect. So if it's the client, extend mercy and be patient with the client. If it's you, be honest, admit it, and then be patient as you are trying to rebuild that trust. Don't get discouraged through all of this. Even if the client goes MIA or you don't get the outcome that you had hoped for from the court hearing or your representation, you're listening and making sure that the client's voice was heard matters a lot. The client's voice being heard empowers that client. We're going to empower that client. And you listening and really listening and not judging and providing a safe space, building that trust, and making sure that that client's voice was heard will make a huge difference in that young person. Really quick about courtroom advocacy, dependency and termination proceedings. Removing a child from his or her family can also impose trauma. Whenever possible, families must stay intact. However, that doesn't mean that a kid should stay in a foster care placement just as a form of stability or stay at home. If it's a place that's causing them harm, obviously that's a problem. But understand that sometimes our systems are causing more trauma than they need to. They are causing more problems than they should be because we're making assumptions about people for all sorts of different reasons. Juvenile delinquency proceedings, we want to talk to you about the fact that you have to be very cautious that ever playing a role in any of your advocacy. Because what happens is that the judges, especially, and prosecutors especially, turn on this and say, oh, well, we need to hold on to this client. They're more safe in this institution than they are in their community. They're not thinking about the fact that the institution is traumatizing the client. They're not thinking about the client's resiliency. They're not thinking about the fact that this action, whatever is happening is going to most likely desist, and that what we're going to do to the client might make it worse. They get this parental kind of view of this, and now we're making everything worse. So I highly caution anyone of using trauma in your advocacy and juvenile delinquency proceedings. And I just want to mention really quick resiliency, slide 21, promote client resiliency. I'm not going to read all these things because I think you can understand them. But we can help a client overcome some trauma through doing these basic little things. So Operator and Colita, I think I'm ready for conversation and questions and would love to hear some of your feedback and some of the ways that maybe you've had experience with kids who've been through trauma, any input that you might have about providing the best representation we can to kids who have experienced trauma in their life.
All lines are open. As a reminder, if you feel the need to mute yourself, please press star then 6, and to unmute yourself, you can press star 6 again.
So at this time, are there any questions from those who are in attendance?
I know we went through things really, really quick. I normally would do this presentation in person and interactive, but with the context of the call and with the limited time, I wanted to make sure we spent more time on some of the things that I think are most important. I'd love to talk about any of the things that you guys that kind of clicked and made sense. Oh, yeah, okay. Or maybe even some of the things that you're not sure of or didn't quite make sense.
I actually have a question. I don't know if you can hear me.
Yep.
Okay, my name is Jessica. I'm in LA. I do family law, and I'm a first year. And you briefly mentioned being a best interest attorney, and that was sort of different from what you were talking about, and I was wondering if you could expand on that.
So what I have talked about is express interest representation, which most attorneys who are most attorneys who are representing kids in delinquency matters are express interest attorneys. So our job is to advocate for what the client wants. That is our entire role. And with the child welfare system, it tends to be a little bit different. There are some people who are guardian ad litem, and in many states, guardian ad litem's role is to advocate for the best interest of the child and not necessarily for what the child has expressed that he or she wants to have happen. So there are different roles for different attorneys. But I want to encourage those who do represent kids as best interest attorneys, meaning that they are advocating to the judge what they think is in the best interest of the child, not necessarily what the child wants, but to advocate and really think about what that kid wants and really think about what empowering that young person in that way might be do for better outcomes for that young person.
So it's sort of like minor counsel role, at least in California.
Say that one more time.
It's sort of like the role of minors counsel, at least in California, that you're talking about.
In child welfare proceedings?
Yes.
Yeah. So different states call it different things, so I'm not sure what it's called in every state. But, yeah, for a best interest where you have to advocate for the best interest of the child, you might take a little bit of a different view on how to help a young person who has been through trauma. But I really want to, just emphasize, think about the empowering of a young person, listening to what they've gone through, or listening to what that young person wants in that specific case, and advocating for it. Anybody else? Or did I sufficiently answer that question?
You did. Thank you.
Serena, this is Kalita. I actually have a question, and please free if anyone else has a question to kind of think about it. But you expressed that trauma was talking about the traumatic incident with a child is not the ideal thing. That's not something that should be done. It's more so being aware that trauma might exist for your client and being able to adjust your actions accordingly. What incidents or what maybe situations that you can maybe share has it been necessary to maybe have a conversation with the client about the traumatic experience or what may be triggering you to think that this child has endured some type of trauma?
So one example I can give is when I worked at the Center for Children and Youth Justice, I represented a young lady who was 18 years old, had a 3-year-old child, actually was married to a man and been married for a couple of years, and he had been physically and emotionally abused for the entire relationship. So we were working with her on a divorce, and we really needed, it was being contested because she wanted to keep custody of the kid, but Dad had lots of resources and wanted custody of the kid, and it was going to be highly contested, and we knew it was going to need to be something that we talked about. We knew it was going to need to come out in the court case, and so what we did is my initial conversation with her was, I know and I've heard and I understand that there are things that have happened in your relationship that were really difficult, and I'm so sorry for that. When it is time, when we need to get into the details of that, I'm going to tell you ahead of time what meeting that will be in. I will give you sufficient time and opportunity to talk about it however you need to talk about it. And I want to encourage you to make sure that you have your therapist or counselor available appointment or something right after our conversation so that you can get through what having to have just talked about it again kind of caused for you. So that is one situation where I worked with the young person and felt like it was something that we needed to talk about, but it wasn't something I was going to talk about at every single meeting. It was something I was going to give her a heads up about. We were going to plan on when that conversation was going to be. We were going to make sure that she could have the support she needed for following that conversation. And for example, I think for a young person who's in a child welfare case, I don't know necessarily that the express interest attorney needs to get into a lot of what happened. I think maybe a little bit, but sometimes we dig because we think that we need to know everything, and we really don't. I think we really need to figure out, do I actually need to know all that happened, or is a general understanding of it? Now, if it's going to come out in court and the judge is going to ask the kid, you don't want that to be the first time the kid's had that conversation out loud. So if that's what's going to happen, then you need to make sure that you have that conversation in a safe space and go over it and et cetera. But there's just so many times where we default into asking questions about these situations and then really asking for details that we might not need to. So I just want to challenge people to think about when that might be required.
Great. Are there any other questions for those who are on the line?
Yes, I have a question.
Go ahead.
Have you had any experience with alternate dispute resolution programs for which minors could be referred by judges and some kinds of juvenile offenses that qualify to have an alternate mechanism of resolution?
I definitely, restorative justice programs especially, I think a lot of them, when done right, are really good. But talking about trauma, I just want to emphasize that most of the time trauma is not necessarily something that needs to be talked about in those situations. It may be something that might come up in a very surface way, and that without getting into the details and having to basically relive the details of it, I think it's okay because it might get at the understanding between the parties and getting to the real roots of what the restorative justice process is about. But I just think that oftentimes your representation of your client for who's been through some trauma that you might not, I guess I'm repeating myself again, but I think that oftentimes we are bringing up trauma and digging into the trauma when we don't necessarily need to. But in regards to your question, are you thinking that alternative dispute programs are going to be more ones that trauma comes up as being an issue for the young person who's accused of something, or explain to me more about where you're thinking of trauma playing a role in this situation? Did we lose you?
Yes. Well, my experience has been, and that's where the question comes from minors that have been referred for an offense, and in light of the judge maybe didn't want to send them for a program, a specific program, and some cases of minor offenses like aggressions or cyberbullying, or maybe some kid that send a picture, a photo, some of those kind of, when you were talking about testing the limits, like some of the conduct that maybe we have in court when we were younger, that now it's seen as an offense, and how it can be managed through a mediation program, let's say, in which, as you said, some of that information about a kid having been exposed to something that caused trauma can come up. And but still,
most of these cases, especially cases that are eligible for alternative dispute, like restorative justice programs, I don't think that we'll get too much into the trauma when trying to get the judge to agree to allow for this type of program, because it's just not that level of an offense that they're being accused of. But usually it's the smaller level things, and those I think we just really need to emphasize with the judge. This is normal adolescent development. Stop criminalizing kids for being kids. And talking about the adolescent development, I mean, we have Supreme Court cases that have great quotes that we can use over and over again about how kids are different, how you need to stop judging them as if they were little adults, and considering through the facts of where they are in their adolescent development, and that every kid is different, and despite whether they've gone through trauma, that this is just adolescent development. This is just regular kid normative behavior. And there's a lot of research out there, and if you'd like to be directed to some of that research, let me know. I will email me. If you've got the slides, my email's on the last slide, but it's sholthe@njdc.info, INFO, and I'd be more than happy to send you resources on how most of the offenses which kids are brought to juvenile court are actually for regular kid behavior, and not because of any traumatic event, not because of any, they're just being defiant kids or whatever. It's just them being kids. And we'd love to share that with you, because I think that really needs to be reminded to the judges.
Thank you.
Anybody else have any questions? Well, feel free to reach out to me by email. My phone number is 202-452-0010. I'm at extension 112. You can also look up our website at njdc.info, INFO, and we'd love to help answer any other questions that you might have.
Thank you, Serena, for your information and what you shared.
AJ for helping set up this call.
Becky, operator.
All right, that does conclude today's conference call. You may